Delivery of Division Bench Judgment, Criminal Appeal Jail 8 of 22.
Result, the criminal appeal is dismissed. The judgment of conviction of the appellant dated so and so, and the sentence order dated so and so for the offense under section 6 of the POCSO Act by the Learned Special Judge schedule in POCSO case number so and so are hereby confirmed. The appeal stands disposed of.
Delivery of Single Bench Judgment, Criminal Petitions 46 of 25.
Criminal petition dismissed. The interim order dated passed by this court, where further proceeding pursuant to charge sheet number so and so stands vacated. The Chief Judicial Magistrate Alo shall proceed with the case in accordance with law and dispose of the same expeditiously. It is made clear that the observation made herein are confined only to the adjudication of the present petition under section 528 of the BNSS. The Learned Trial Court shall decide the case independently on the basis of the evidence adduced before, it being uninfluenced by any observation made in this judgment.
Is any mention?
May it please to the court, I humbly mention item number 32 and 33 for an adjournment. Legal counseling is out of the station due to unfavorable circumstances. So kindly 32 and 33, Lordship. Maybe after 1 week.
Mr.
El Gamis.
Learned Counsel submits that the Learned Counsel for the petitioner is out of the station, therefore, he prays for adjournment of the matter for a week. The prayer not been objected to by is allowed, so please this matter after a week. Oh,
Thank you. Much obliged.
On the bearing of behalf of Mr. T. Ono for the item number 8.
item 8.
Permit to withdraw this.
Okay. Mr. Learned Counsel appearing on the submits that he has an instruction to withdraw this criminal petition with liberty to file a fresh advice. The prayer is allowed. This criminal petition hence dismissed as withdrawn with liberty as prayed for. Okay. Agreement was not annexed. Okay.
Lordship, I appearing on behalf of my senior advocate is thus the item number 29.
Item
number 29 for adjournment.
29.
29. My senior advocate health is not well. That's why Lordship pray for only
Mr.
Mr. Bomga Poyam, B Poyam.
Your name, your good name.
B Poyam.
B Poyam.
G.
But you are senior here.
Lordship, my name is reflect here, but my name is enrolled here. That way.
You are senior and junior loan.
I'm your junior assistant. Assistant, sir. Assistant.
Okay. Mr. B Poyam. Learned Counsel submits that is senior. Who is your senior?
S does.
S does. As some person who is to appear in the, who is to argue in the matter is has some personal difficulties today. Therefore, pray for adjournment. As prayed for, list this matter after
1 week.
after a week. Okay.
You'll also provide to maintain unlisted item here also. Right, the matter to be taken up on Monday.
Okay.
Lordship, I beg to mention item number 30.
1330.
30.
Yes.
Can it be listed after 1 week?
Okay. As prayed for by Mr.
Emmet,
County Counsel for the petitioner, not being objected to by the counsel appearing on behalf of the respondent. List this matter after a week.
after
Okay.
highly open.
May I, Lordship, I beg to mention item number 35. On behalf of T. Take, with the consent of petitioners.
Why it has been listed, Mr. Sibo? Is
List-
one in order?
Yes, Lordship. And my senior is due to medical problems. He could not appear today. And we have taken consent to,
Okay, Mr. Sibo, County Counsel, some that his senior he has some medical problem, therefore pray for listing this matter after
kindly, this matter may be listed on 17/8.
matter on 17/8. The prayer not been objected to by. Have you informed the other
Yes,
side?
Lordship.
Okay. We also submit that he has also obtained instruction, also obtained consent from the County Counsel for the respondent. As prayed for, list this matter on
17/8.
17/8. Okay.
Mm.
This is 35. Okay.
May I, my lord? My lord, I beg to mention item number 31, bail application.
Okay.
My lord, the trial court record is yet to be arrived. Therefore, matter may be adjourned and fixed on 29th. The trial court record is yet to be
Okay,
arrived.
okay. Okay, Mr.
P. Chiring.
Mr. P.
Chiring.
Hearing County Counsel for the petitioner. The trial court record is still awaited. In view of the above, list this matter after
29th of this month, my lord.
in view of the above and is prayed for by the County Counsel for the petitioner. List this matter on 29.
29th. Obliged.
Okay.
Man of speech. I beg to mention one unlisted matter for listing on Monday.
Monday. Okay.
Your Lordship, I would like to mention item number 25.
25.
Yes, Your Lordship.
Yes.
With the consent of other party, let the matter be listed after 2 weeks, Your Lordship.
Inform the other side.
Yes, Your Lordship.
Miss
Miss R. Takam for Learned Senior Counsel, Diki Pangin.
R.
R. Takam,
Takam, County Counsel, appearing on behalf of Mr. D. Pangilani, Senior Counsel for the petitioner, with the consent of the County Counsel for the respondent, prays for adjournment of the matter.
yes. After list the matter after 2 weeks.
Okay. For 2 weeks. The prayer is allowed. List this matter after 2 weeks.
Oblige, Your Lordship.
Item number 2.
May I please, my lord?
Yes.
My lord, this CRPC civil revision petition is filed for challenging the legality and validity of the judgment and order passed by the Inter-Village Territorial Customary Court of Leh Pureng Circle, which passed under Arunachal Pradesh Civil Courts Act 2021. So, my lord, the authority which they have passed, they have no any jurisdiction to decide and passing judgment.
Who lodged complaint?
My lord, initially I made complaint before the village authority of my concern village,
Can we
Gauhati.
see just once?
Yes,
Where is your complaint?
my lord, in my complaint is page number 19, my lord, annexure number 2.
19.
Yes, my lord. This is initially I made complaint to concern Gaubra once
Okay.
in
City of the
Navamtali.
village.
Yes, my lord.
Okay, then what happened?
So after this complaint, this concern Gaubra is initiated for proceeding, my lord, for settlement. There is a land dispute.
Mhm.
So What happened, my lord, the respondent, they have not agreed to have mail in the concerned village. So by avoiding this proceeding of the village authority, concerned village authority, he directly jumped to the territorial customary.
Okay,
court.
he filed,
Yes, he has filed.
present one.
Yes, my lord.
This,
lord,
customer,
is-
this mail judgment is in his complaint.
Yes, my lord. Is in as per his
Did you
complaint.
participate?
Yes, my lord.
Did you participate?
My lord, I was participate any first day, but I have verbally objected that because my complaint is pending before the village customary court, where matter has to be heard, my lord. So as per provision, my lord,
What happened to that complaint lodged by you?
my complaint is still pending, my lord.
Still pending?
Yes, my lord. So, my lord, here in the law point of view is that
This was lodged on 14/8,
Yes.
25. And then the complaint of the respondent is when it was-
28/8.
28.
Yes, my lord. I was lodged complaint on 28/8/25. My complaint is still pending before the concerned village authority, and then they have filed complaint on before the territorial customary court on 13/10, my lord. 13/10/25. 13/10/25. It is in page number 23 to 24, my lord, annex 3. So after that, my lord, I have verbally made objection before the.
They filed 13/10.
Yes, my lord. They have filed 13/10/25.
Okay.
I
so
was
this-
filed on 28 August 25.
Okay.
So, my lord, they have no any jurisdiction to decide the matter as per provision. Lord, see, we well aware that as per section 15 of Arunachal Civil Code Act, if this
54.
this authority which they have passed the judgment and order, they are the appellate authority as per section 15.
Yes, yes, wrong.
Notice may be issued.
Notice and issue, okay.
Notice maybe is to till then, my lord.
Rama
Impugn judgment may be suspended, my lord. Till
and Rama, Land Council for the petitioner. Also had Ms. Wang, Land Government Advocate for the state respondent number 1. This petition, application under Article 227 of the Constitution of India is directed against the customary mail judgment dated 31/3/2026
31/3/2025. 2026, my lord. 31.
passed by the territorial
Inter-village territorial
intervillage
customary court.
by the Inter-Village Territorial Customary Court of
Labor.
Leporian Circle. In case between descendant of late Navam Tadung versus descendant of late Navam Tade. Descendant of Navam Tadung represented by Shri Navam Hark and 3 others, and versus descendant of late Navam Tade. It's late, late Navam
Yes,
Tade.
my late Navam.
And late Navam Tade represented by
Now,
Shri Navam
Navam
Erika
and Navam,
and
who is a petitioner here.
another, and another bracket close, It is submitted that the Land Council for the petitioner submits that earlier the petitioner knows complaint. Where is your complaint?
My lord, my complaint is page number 19, my lord. Page number 19, and except 2/6, page number 19, my lord. Dated
Petitioner knows
24/8/2025.
complaint before the GB of Tabu
Tabu
village,
Yes, ma'am.
Napoleon circle against the respondent
Yes, my lord, against the respondent.
regarding land dispute. For settlement of land dispute between him and the respondent. This is not a, is it a complaint?
Yes, my lord, complaint was made. In fact, my lord, subject is not mentioned because they are blazers, so they have no any good idea to write letter to the complaint to the authorities. Subject is in fact not mentioned, but content they have mentioned the dispute which between the present private respondent and
It's a land dispute
yes, my lord, land dispute.
regarding the agriculture land,
Yes, my lord.
agriculture and horticulture land between the petitioner and the respondent. Stop. While the said complaint was still pending, the respondent lodged complaint before the Intervillage Territorial Customary Court of Leporian Circle, and by an order dated 31 by the impugn order dated 31/3/2026, the Intervillage Territorial Customary Court of Leporian Circle decided. Part and ex parte.
Yes, my no ex parte was not. In fact, my lord, first day I was made objection, and thereafter I left from the mail.
Okay,
So they have likely they have passed ex parte, my lord.
the where is the final operative portion of the
Judgment, my lord.
sorry, the order?
Operative portion, my lord, in page number 18, my lord, in my the judgment. Para 13, my lord. Since
Okay.
to-
What is the decision, last decision?
decision, my lord, they have even given permanent injunctions.
Okay,
Permanent injunctions to the private respondents of my plot of land, which they have included. All the total land 24,750 square meters.
the declared the disputed land in favor of the respondent,
Private respond, my lord.
private respondent number
2, 3, 4, 5.
2, 3, 4, and 5.
Yes.
And also pass and permanent injunction against the petitioner. Stop, huh? Petitioner prohibiting their entry in the said land. It is submitted that the as per section 15(4),
Sorry, my lord.
under which
My
provision
lord,
they have
section
no
15,
jurisdiction.
section 15, the subsection 4, which amended in 2022,
15(4) of the
Arunachal Pradesh Civil Code.
Arunachal Pradesh Civil Code Act amended 2022.
2022, my lord.
The Inter-Village Territorial Customary Court
The appellate custom, appellate.
is an appellate authority and does not have the original jurisdiction to try the dispute. As such, impugn order is in, is contrary to the said provision, and therefore praise for setting aside and quashing of the impugn order. Stop. That between of it. Hence, Ms. Wang, Lani Government Advocate, accepted notice on behalf of the respondent number one, state respondent number one, no formal notice is required to be sent to the same respondent. Stop. The petitioner shall take steps for service of notice upon the private respondent number 2, 3, 4, and 5 by speed post regulate by usual process within a week from today. Stop. Hold for the relevant record, release this matter after 4 weeks.
4 weeks now.
Stop. Having considered the submission made and on perusal of the record. Perusal of the document on record. It is covered that the operation of the impugn judgment dated 31/3/2026 passed by the Inter-Village Territorial Customary Court of Leporian Circle shall remain stay till the next date, next returnable date. Okay.
Deeply of it.
Matter number 3,
My lord, here similar matter, my lord, which passed by the this Old Toru Circle Gaubra Associations.
Similar.
Similar matter, my lord. Supposed to be conduct in the concerned village authority, so they have conduct directly matter sent to the inter-village circle level customary court. So they have passed judgment, impugn judgment, my lord.
This was also
The
passed
dispute is, my lord, two village.
inter-village.
Yes, my lord. Inter-village. In fact, my lord, in their judgment, they have no written inter-village, but they have written as a Old Toru Circle Gaubra Association, Gaubra Customary Courts. So they assume as a inter-village territorial customary court, my lord. This is passed by Toru Circle, my lord, within Sagali administrative jurisdiction. And Ali one is a lay putting circle. So, my lord, here also, my lord, dispute is in between the two blades, one Pepso blade and Mapsoro blades. So, initially complaint, I have launched complaint before the circle officer, my lord.
Circle officer.
Yes, my lord. So, circle officer is supposed to refer back to the concerned village.
Now, under the present provision, you don't have to file complaint before the circle officer also. Straight away, it should be before the
Yes,
number age you have done in the other case. Earlier
Yes,
case.
my lord, that was there. So, they have not made complaint to the concerned village authority, my lord. That is there, my lord. So, they have made complaint to circle officer, and circle officer authorized the Old Toru Circle Gaubra Customary Code, my lord. So, there was a meeting.
Circle.
Yes, my lord.
Circle level means inter-village.
Inter-village, my lord.
So it comes under whatever name called.
Yes, my lord.
Okay. So you accept notice on behalf of the respondent. State
One and
respondent. Okay. Almost similar order, huh? Hard,
Similar,
same.
my lord. Only
Hard
two
will be
parties
same, huh?
may be changed, my lord.
And, this will be challenged. This is ex parte,
Ex parte, my lord. This is
Okay.
ex parte, my lord.
directed against ex parte judgment order dated 30/4/2026. Passed by all
Old Toru Circle
Toru
Gaubra
Circle Gaubura
Customary Court, my lord.
Customary Court. What is this subsequent order?
My lord, subsequent order has circle office after passing this judgment, they have forwarded the matter order to the circle officer, and circle officer has also
and
passed
the
another
subsequent-
order, my lord.
And the subsequent order dated 1/5/2026 passed by the
Circle
circle
officer,
officer, Toru Circle. Stop, para. It is submitted that the petitioner Your complaint is at page 25.
Yes, my lord, page number.
Page, which page?
Yes, my lord, page number 25 is my initial complaint to the,
So how many of you are there?
my lord, we have almost 26% from.
How many petitioners are there?
Sorry, my lord.
How many petitioners are there?
My lord, 3 petitioners are here in the
Okay.
present petition. The other petitioners, they have authorized,
Okay.
other blazers, they have
Submitted
authorized.
the petitioners. Initially, the petitioners lodged complaint before the circle officer, Toru Circle, on 27/3/2026 against the illegal encroachment and unauthorized boundary demarcation by whom?
Individuals of Pepsha village, my lord, lead by one Sri Tabarama,
By
Sri
individual.
Murang Pol.
Tabarama is a respondent.
Yeah, no, my lord, hearing not respond, but
Who is respondent then?
my lord, respondent is a person who conducted the survey without authorized from the.
Sorry. Against whom you
My lord, Tabagom. Tabagom is represented on behalf of Mapsho village, my lord, in that proceeding, my lord. And then Murang Kuli, they are the private
Father-
respondent.
by
Tabagom,
Tabagom.
Murang Kuli.
Tabagom is a respondent here.
Yes, my lord.
Okay, the against the
Murang
respondent, that means against the respondent,
Yes, my lord.
against the respondent for her. Okay, then complaint against the respondent for illegal encroachment and unauthorized boundary demarcation.
Yes, ma'am.
However, the circle officer, instead of endorsing it to the Gambura of which village you said?
Pepsho
Pepso
village. We have made complaint, my lord.
Pepso village
My lord.
has illegal has endorsed the matter straight directly to the, where is that the endorsement?
My lord, endorsement is in page number 31, my lord. For the dated 23 March 26.
To the whom you said, whom endorsed it was?
My lord, here Taba Nana GV Sangrik, and then and president of Old Toru Circle Gaubra Association, who is one
The president of Old Toru.
circle Gaubra Welfare Association.
Where do I find
My lord, my lord, in last paragraph, page number 31, my lord. Last paragraph,
the
my lord.
president? Okay,
Direction and
Endorse-
suggestions.
the case to the GB Sangrik along with the president of Old Toru Circle Gambura Association to this was for settlement.
Yes, my lord. Directed to verification and settlement, my lord. And
For
also
verification
endorsed
and
one
settlement.
one PI of Toru Circle,
To verification and settlement of the case under the supervision of PI
PI
Toru,
Toru.
PI Toru
Name is not reflected, my.
staff. And where is the settlement?
My lord, settlement is not there, my lord.
Means the
Thereafter,
judgment.
judgment is page number 20, my lord. Final judgment they have given, ex parte judgment. Page number 20 till 22, my lord.
Who by impugn order dated
Even, my lord, in content of the judgment, the date is not mentioned, but one of the GB's signature, there is
30.
mentioned the date, my lord.
dated 34
30 April 26, my lord.
2026 as declared. Where is the operative portion of the order?
My lord, operative portion is page number 22, my lord. Page number 22, the disputed land rightly belong to Mapsho village based on long standing positions, historical settlement and customary uses. Number 2, my lord.
Where?
Page number 22, my lord.
Okay.
Impugn order.
Declare the name to be belong to the respondent
Yes, my lord, respondent village.
belongs to Meposo village. Mepsoro.
Mapsho village.
Mepsoro is a village
Yes, my lord, village.
belong to Mepsoro village based on the basing on long standing . Okay, this one. Judgment and completion harmony. Based on the long-standing possession and customary usage. Stop, huh? This was decided in your absence.
My lord, I was present first and second. Last day, I requested the matter be again referred back to concerned authorities.
Okay,
Based on-
same,
but-
same.
Yes, my lord.
Okay, last paragraph would be same. That means
The ex parte judgment is
the-
clearly they have
the,
mentioned ex parte judgment.
the learning council for the petitioner submits that the what is this authority you said? It doesn't say the name of the authority also.
My lord, in judgment, nowhere date is also mentioned and how many how many days it was conducted, that was also not mentioned. And the date of judgment is also not given. Only one of the Gauhati, they have put signature on their date is
The
mentioned.
authority name is not there,
Yes, my lord.
court name,
No court name is there, but only, my lord, which they have,
endorsement of
my
order.
lord, which they have.
Where is
issued.
that?
My
Where
lord,
was that? Okay,
My lord,
It is
issued, they have
submitted that-
so mail order, my lord.
the
Page number 32.
page,
Page number 32, they have issued mail order, my lord.
mail
Page
order.
number 32, my lord.
Who
Annexure-
issued? All Toru.
Yes. My lord, they have
Okay.
all Toru Circle, Gauhati,
It is
customer.
all Toru only, okay. It is submitted that the all Toru circle Gauhati customary code. Okay, is, it's a circle level,
Mile circle level.
which is equivalent to the intervillage territorial customary
Yes, my
code,
equivalent to intervallate to customary.
which according to the Land Council for the petitioner doesn't have, lacks jurisdiction. Lacks original jurisdiction, which according to the Land Council for the petitioner is an appellate authority
Yes.
and therefore lacks original jurisdiction to decide the decides the decide such complaint. Stop. Huh? Para. Decide such complaint as per the provision under 15 subclause 4 of the Arunachal Pradesh Civil Code Act 2000 amendment, Civil Code Amendment 2022.
22, my lord.
Stop. Huh? Upon hearing the counsel for the petitioner and on perusal of the record, it appears that the petitioner has raised an arguable questions. Accordingly, let a notice be issued to the respondent. Stop. Huh? Since Ms. Wango accepted notice on behalf of the state respondent, Lani government advocate, I accepted notice on behalf of the state respondent. No further notice is required to be sent to the said respondent. The petitioner accepted text for service of notice upon the respondent number. How many respondents? Rest of the
My lord,
respondents.
here respondent number, private respondent is, my lord,
Private
two
respondents.
respondent, two private respondent.
Number 2 to 4 by a registered post with 80 as well as by user process within a week from today's start. Call for the record. Huh? List the matter after 4 weeks. Similar. Huh? In the meantime, it is in the meantime. it is provided that in the meantime, the operation of the impugned judgment. Is it called judgment or what they call
Ex
it?
parte judgment. They have given ex parte
Impugned- it was an impugned-
34.
impugned judgment order. Dated 34/2026. Passed by the
All Toru circle.
All Toru Circle,
Gaombura.
All Toru Circle, Gauhati Customary Court, Selvedon State till the next returnable date. Okay.
Much of. Deeply.
Item number 4,
May I please, Lordship?
Hmm.
Your Lordship, in this revision petition, I have challenging the order passed by the Inter-Bilateral Customary Court. The order was passed by that forum without the jurisdiction. Your Lordship, initially, the respondent here filed a complaint before the Deputy Commissioner and the ADC. And after taking into consideration of that complaint, they forwarded the complaint to the Kabang member. Kabang member, Your Lordship. The complaint of the respondent, Your Lordship, will find at page number 47 and 48. At page number 49, Your Lordship, will find the complaint filed by the respondent before the ADC. Copy to GB President of Siomi District, Your Lordship.
Where is the complaint page?
Page number 49, Your Lordship,
49.
49. And page number 50, Your Lordship.
This is the complaint letter.
Yes, Your Lordship.
What is this copy? Where is the type copy?
Your Lordship is not visible. Here in complaint letter, Your Lordship, the respondent claiming the land of the present petitioner, Your Lordship, and they claiming the entire area.
When you find such letter, which is, see, this is not the proper, this should have been actually typed out.
Yes, Lordship.
It's in a way,
Yes,
it doesn't look nice.
yes, Lordship.
You should type such letter or the notification order, whatever may be,
Yes, Lordship.
type copy should always be.
Obliged, Your Lordship.
Okay, what is this? This is the complaint by whom?
The respondent, Your Lordship.
Respondent lodged complaint before ADC.
Yes, Your Lordship. Copy to the president of the GB president of the Siomi District, Your Lordship.
What is this complaint about?
Complaint, Your Lordship, the ancestral land of the petitioner herein, a claim by the respondent without any evidences and documents.
What is their claim?
Claim is, Your Lordship, the subject is, Your Lordship. May I please, Lordship? The land ownership representation extends from Yorlung Nange Dadi to the line of actual control, progressing left side towards the tri-junction, and from Lamang to Lola, Halungogo, LOC. An objection to the ongoing discussion of the 23 clan A and B regarding the proposed acquisition for the construction of the BOP border outpost by the ITBP at Yorlung Nange Dadi road construction from Lamang to Lola, Hilung Ogo. Your Lordship, the entire area which has been mentioned by the respondent falls within the ancestral land of the petitioner here, Your Lordship.
Okay, what happened thereafter?
Thereafter, Your Lordship, the matter was taken cognizance by the Kabang member. Your Lordship will find at page number 46.
46.
46, Your Lordship. This is a Kabang order where Your Lordship, in the last paragraph, now, therefore,
This Keva order is the impugn order.
no, Your Lordship, impugn order is at page number,
Now, what order is this? This is Keva
the
order.
order is, Your Lordship, after the complaint filed by the respondent, marking the copy to the president of the GB, they have taken the cognizance of the matter.
Who marked the president?
At page number, Your Lordship will see page number 50, last copy to Sri Tagamruchi, GB President of Siomi District. Thereafter,
Itu?
yes, Lordship. The Kabang was taken the cognizance of the,
Copy to, okay.
yes. Your Lordship, at page number 46, in continuation to the land dispute between 23 clan A and B of Buddhist community, the Kabang body has received an application letter dated 10 July 25, addressed to the Deputy Commissioner, and dated 21 August 25, addressed to the ADC Mechuka. This 21 August 25 addressed to the ADC, which has been, Your Lordship, seen in page number 49 and 50. Thereafter, the Kabang body directed the respondent to submit evidences.
Who directed?
This Kabang body, Your Lordship.
No, the complaint was lodged before the ADC.
Yes,
Did
Lordship.
endorsed to whom? Endorsed the case for settlement to whom? Which authority?
Yes, Your Lordship, here and seen in past paragraph. In continuation to the land dispute,
In continuation.
yes, Lordship. Clan
No, I'm
23,
asking you my question, specific question.
yes, Lordship.
This complaint was addressed to additional deputy commissioner.
Yes, Lordship.
Whether the additional deputy commissioner endorsed to anyone, any authority?
No, Your Lordship. The Kabang body has taken the cognizance of the matter.
How
Yes.
how it can? It was
Your
not
Lordship.
for the Kebang.
Your Lordship, they have complained, respondent had submitted this complaint letter before the president of the GB. Copy 2 was marked. Accordingly, they submitted this
And what did
application.
the ADC do then? Because the letter, the complaint is addressed to ADC.
Yes, Lordship.
What did the ADC do?
Your Lordship, thereafter, we have no any document to show that what had been done by the
No, on,
ADC, Lordship.
on what basis this Kebang was settled? Only copy was given to them
Yes, they have submitted this complaint letter to the GB person.
without authorizing, without any complaint. Because the
Your
complaints
Lordship,
were never lodged before the Kebang or the GB.
yes, Lordship.
How do we know that this Kebang order is the settlement or the settlement of the complaint lodged before the ADC? How do we know?
This is a complaint filed by the respondent, Your Lordship, here.
Before whom?
Before the ADC and
ADC
Deputy
is never
Commissioner.
endorsed.
Yes, Lordship. Exactly, Your Lordship. That's why I submitting Your Lordship. Thereafter, the Kabang body has taken cognizance. They,
Where do we find that it has taken cognizance?
yes, Your Lordship, here in page number 46.
No, probably, Mr. Land Council, you are missing out some document, I think.
Yes. Apart from these documents, we have no records, Your Lordship.
It doesn't have any link.
Your Lordship, in past paragraph, they have, the Kabang body stated 21 August 25 addressed to ADC Mechuka. This application is, Your Lordship,
Kebang body has received an application letter from Rancho. Addressed to DC.
yes,
Where is
Lordship.
this address to DC letter?
You also will find at page number 47. This is a complaint filed by the respondent before the Deputy Commissioner.
Okay, two letter.
Yes, and ADC itself, Your Lordship.
Whether DC endorsed,
No, Your Lordship.
DC also did not endorse.
No, Your Lordship.
DC's complaint before the DC, not even copy marked to the Gambura.
Yes, Lordship. In this annexure I, page number 46,
Just read, yeah.
yes, Lordship.
You are which party? There are two parties.
Yes, Lordship.
You belong to which party? Kochung.
No, Your Lordship. I belong to Tasi Onju clan.
See, there is no complaint before the GB. The complaint is before the Deputy Commissioner and ADC who never endorsed. You have just said that received. From whom? Because no complaint was made. So are you challenging this? order?
No, no, Your Lordship.
Okay, then which?
Your
you are
Lordship,
challenging which one?
what happened, Your Lordship, what happened thereafter?
Hmm.
After this Kawang order, the respondent herein again filed a complaint before the Deputy Commissioner at page number.
What was the decision there in this?
Uh,
paper?
In this Kawang order, Your Lordship, the respondent is directed to produce the evidence, documents before the Kawang body. If
When they produce?
no, they have failed to produce any documents.
Hmm.
Instead of appearing before the Kawang, they again
No,
approach
here
to
no,
the
we can,
appear before the Deputy Commissioner.
Hmm?
And
they appear before the Deputy Commissioner.
again approach the Deputy Commissioner,
Yes.
filing a
Clearly.
complaint against that Kawang member.
Yes.
Reason that the Kawang body is some family member of the,
They are right.
yes,
Right.
Lordship.
Keba doesn't have any power and jurisdiction to try without any complaint.
Yes,
The complaint was before the DC, ADC.
Yes, Lordship.
Hmm.
Thereafter, Your
They are
Lordship.
right. Respondent is right here.
Yes, Lord.
Hmm.
I admitted that, Your Lordship, they have filed a complaint against that Kawang body. Thereafter, the Deputy Commissioner again communicate that complaint letter to the President of GB, Siomi district.
Same complaint.
Yes.
You should have
again,
shown that immediately. Where is that? I was trying to link. Exhausted.
at page number 51, Your Lordship.
Page
51, Your Lordship. Type of
51.
copy is 53, Your Lordship.
51.
53, Your Lordship.
What?
Type out copy.
51?
51 is, Your Lordship, this is the original, and type out copy is 53, Your Lordship.
Okay. This is complaint.
Yes.
Formal complaint against the
Collegiate petition by
closed by whom?
a respondent here, Lordship.
Okay. Earlier also it was a respondent.
Yes.
Okay.
The formal
Yes.
complaint
It's a
against the,
formal complaint before the Deputy Commissioner.
yes, Lordship.
Then complaint.
Yes, Lordship.
Okay. Then what happened?
Thereafter, on 16 September 25, the Deputy Commissioner forwarding a complaint letter to the all GB Mechuka subdivision.
Okay.
Thereafter, the matter was again taken cognizance by the President of the GB President Siomi district at page number 58, Your Lordship.
To all GB.
Yes, Lordship.
Oh, this is Deputy Commissioner. To all GB. Mexico. Who is this? Who issued this? GB. Okay, the GB has issued to all GB.
Yes, Lordship. Your Lordship,
What it says,
Your Lordship, in the top of the letterhead,
circular.
it's written in the Court of Intervillage Territorial Customary
okay,
Court of
okay.
Mechuca Subdivision, circular.
Mhm.
It assumed that, Your Lordship, my matter has been first instance taken by the Intervillage Territorial Customary Court.
Mm.
The complaint filed by the respondent here, Your Lordship.
Mhm.
Thereafter, Your Lordship, the Kawang body was constituted and passed the impugn order at page number 59, which I have been challenged in this revision petition, Your Lordship. Wherein, Your Lordship, my ancestral
This
land,
is according to you, this is intervillage customary code.
yes, Your Lordship.
GB. Which village the GB and GBs are from? Same village?
Yes,
Different or
Lordship.
different village?
Your Lordship, there is different villages, the GB of different villages, 8 GB, GB of
Where do
different
we
villages.
find the seal of the customary code? District GB. Okay. District GB president.
Yes, Lordship. Thereafter, Your Lordship, what happened?
Hmm.
The demarcation was done on 4 July of 26, wherein the land of petitioner has been demarcated in favor of the respondent, Your
What is
Lordship.
the decision?
Decision, Your
The
Lordship,
decision here, where is the?
operating para, Your Lordship, page 60,
Hmm,
para 3.
okay,
Regarding the land claim as Paye and Pachong of the Kochung clan, based on the statement recorded of the witness during the proceeding, the Kawang body find it clear and declared that the Kochung class does possess the ancestral land and the forest name Paye and Pachong. However, the controversy regarding the exact location and the boundary of Kochung clans Paye and Pachong and Tasu Onju clans claim shall be definitely demarcated and decided by Kawang body after only spot site verification is successfully
okay. Where is
conducted.
that demarcation?
Your Lordship will find at page 62. Kawang body finding report dated 4/7/26.
Impugn order.
Yes, Your Lordship.
Hmm.
Your Lordship, my submission is, as per section 15 clause 4 of Arunachal Pradesh Civil Court Act, the Intervillage Territorial Customary Court is a appellant court.
Who are the parties? Yeah.
Parties are the Your Lordship is,
Made the state also parties.
no, Your Lordship.
Okay. Mr.
B or Your Lordship.
Land counsel for the petitioner. Okay, the present application has been filed. Present application on Article 227 of the Constitution of India, read with Section 115 of the Civil Procedure Code 1908, has been filed. Extailing the order dated 21/10/2025 and subsequent demarcation report dated 4/7/2024 and 26 passed by the Where is the court name? Intervillage.
Yes, Lordship.
By the Intervillage Territorial Customary Court or Apex Court, C. Yomi District. Case 64 is the complaint lodged by the respondent,
Your Lordship, it is lodged by us, Your Lordship.
lodged by you,
Yes.
but you also lodged before the intervillage only then.
Your Lordship, thereafter I have filed an appeal before the Intervillage Territorial Customary Court.
Okay, just a minute. But then you said that it was decided by intervillage customary court.
Yes, Lordship.
Okay, intervillage territorial customary court of Mechuka.
Yes, Lordship.
Okay, write it.
Siomi District.
Mechuka subdivision, Siomi district. Pakar. It is submitted that the intervillage territorial customary court is an appealed authority under the Arunachal Pradesh Civil Court Act, Civil Code amended at 2023 under clause under section 15. Clause 4. Under section 15 of clause 4 of the Arunachal Pradesh Civil Code Act, the right it, the Intervillage Territorial Customary Court is an appellate authority, and it lets the original jurisdiction to try the complaint case regarding the land dispute. Stop. The Rani counsel for a petitioner submits that by the interim order dated both the date, the intervillage territorial customary court of Mexico has exceeded the jurisdiction of jurisdiction. Exceeded the jurisdiction of the customary court of issue notice returnable by 4 weeks. Start. Call for the relevant record. Stop there. The petitioner accepted steps for notice. Service of notice upon the respondent by a speed post regular process within a week from today. Stop there. List this matter after 4 weeks. Stop there. In the meantime, the operation of the order repeat same and demarcation already did so and so. Issued by the inter-village territorial customary court of Mechuca subdivision, Stephen district shall remain state till the next returnable date. Okay,
Obliged, my lords.
please dismiss after 4 weeks.
Item number 5.
Yeah.
certain corrections. What's a paragraph? What's a paragraph?
So this is same. Have you given the detail of the case
Yes.
pending against him?
Paragraph 21, Lordship.
Para 21.
Hmm. In fact, in the Biporia police station, Chimpu,
Where
and
is the
Itanagar.
notification?
These 3 cases are under investigation, Lordship.
Notification.
Paragraph.
Hmm?
Notification.
Is it okay?
Yes, my lord, the 3 cases has been disclosed, my lord.
Okay, no,
Total 2 cases, including the.
although no section and the status of the case.
Yes, my lord. Status,
Don't have to give detail.
status they have not mentioned, but
The
only
detail is not required.
required, my lord. They have to mention the status, whether.
Yes, status,
yes.
well, acquitted,
Acquitted,
convicted.
under investigation, or whether trial is
Yes,
going on, whether.
that is required actually.
Yes, my lord.
Lordship,
It's there. Every detail has to be provided.
I've submitted, as I was submitting, Lordship. Investigation are going on, Lordship. These are all subsequent bail that was, FIR dates were filed and registered, Lordship. After I was arrested, Lordship.
And then, my lord.
You said if it was involved, if yes, particulars and decision thereof. Detail has to be provided.
Status.
If it is only simply that the case is under investigation stage or pending trial. If yes, particulars and decision thereof.
Yes.
Mhm.
Because unless that is mentioned, we do not know,
Yes, ma'am. That's true, ma'am.
which does not contain this, in the application which does not contain this information shall be placed before the bench with the necessary information. So what to do?
Lordship, here I'm reading the application, this notification. It says the petitioner application shall also mention whether he is involved in any other criminal case or not.
Yeah.
Mhm.
Lordship, we have just mentioned that he has been named in all those FIR
If yes,
case registered.
continue, if yes,
If yes, particulars and decision thereof.
Yes.
that means entire
Detail has to be provided.
detail. If it is pending.
Pending
Suppose in this case, the Puria police station case number still under investigation. Chimpu police station case still. charge
Pending,
sheet
all are
filed,
pending
etc.
investigation.
That has to be provided, ma'am. The details.
Lordship, that one line, Lordship, I am submitting, Lordship. Fairly, I am submitting, Lordship.
No.
That ought to have been added. Yes, I agree, Lordship.
Yes, we will not
But-
adjust. We'll not adjust, huh? Because once this court adjust, we'll have to adjust everybody.
Yes.
This is, see,
These are all 3 cases that is pending investigation.
you correct it, we'll take it as the last item. Or addition cannot be done in that way.
But addition, my lord, what the difficulty is, my lord, once, my lord, the court is passed the order, my lord. It's amounting to, my lord, entertain the application, my lord.
Right.
So once this is entertained, there is no any purpose, even if the additional affidavit is filed. The purpose will be repeated, my lord.
Only one line, Lordship, are pending investigation. Only 3 lines.
No, 3 lines.
Yeah.
Even
my
if
lord,
one,
My lord,
even if one line also,
what difficult would be, my lord?
one word also.
Later on, my lord, if CD comes,
Hmm.
and if CD says something,
Hmm.
that will be suppression of fact later on, my lord. So that has to be disclosed as on that, what is
Will
this
not
status?
go. Will not go for it. So deliberately will not, knowing that it's not complete,
We'll withdraw, Lordship.
Ah.
I'll apply. We'll add that line.
better.
Yes.
If you can file today, that is also okay. I have no problem. But then incomplete one we want.
Otherwise, also this matter will be listed before your lordship also. Even your lordship go outside, it will be the outstation because it was withdrawn before your lordship. Now it will be considered the second one, madam. As per the notification 27, madam.
No order was passed.
A prior one, my lord, they have withdrawn, my lord.
No,
If-
no, even then, but
if-
no order was passed.
Even in case of withdrawn, my lord, it will be placed before your lordship. My lord, notification
You face
27.
problem there
20
for
notification
one
20.
small mistake. And it was deliberate, it appears.
Lordship,
Because
in
you're
fact,
knowing at what stage you did not
Lordship,
disclose.
that line
It was
we also
deliberate.
have added.
And this deliberate is unpardonable.
Lordship, I'll agree.
Ah,
Lordship.
okay.
I'll add that line.
Okay, Mr. J. Jini. Seek permission to withdraw this bail application with liberty to file a press after making necessary corrections. To which Mr. Additional people has no objection. Prayer allowed. This bail application is dismissed as withdrawn with liberty as break for.
Yeah, obliged, madam.
Item number
Right.
6,
Please, Lordship. Lordship, this anticipatory bail application is in connection with SCBPS case number 4 of 26. My Lordship has came across the fact of the case in previous, some applicant has already moved bail application, anticipatory bail application.
He was at the time, who is this?
He was holding the post of assistant engineer ASW planning. And thereafter, before lodging of complaint, he has been promoted to the post of executive engineer and he has been
When?
released.
When?
Lordship, he was promoted on 16/9/2024 and released on 15/10/2024. But
16?
15/10/2024. The complaint was lodged on 6/8/2025. Just almost 1 year prior to, after releasing him from the Changlang.
No, he was in Changlang.
Yeah,
Since when?
since 2017, Lordship.
Oh,
Lordship.
you are the main person.
Lordship, he was the ASW planning.
Okay. Thereafter, subsequent planning, only in the planning since 2017 to 24,
No, Lordship, till 22, Lordship.
22. And then
Yes.
from 22, he was in the
Yes,
site.
yes,
I think he has a problem.
Lordship.
He is the
Lordship,
one,
here-
he who knows everything.
Lordship. Lordship, here, my respectful.
Will issue notice? What is that?
Yes, my lord. Lordship,
Will issue notice?
I'll accept.
You produce case direct
My lord,
next day?
my lord.
Okay.
Lordship, I
Ah,
have small,
Mr.
small
Lordship.
prayer, Lordship.
Learned counsel for the petitioner. Also had Mr. Opada, learned standing counsel for ACB staff. This is an application. Okay, this AB,
AB, Lordship.
okay. By filing this application under section 482 of Code of what is this? Code 82 of Bharatiya Nagrik Suraksha Sanhita 2023. The petitioner is taking ground of anticipatory bail, the pre-arrest bail in connection with Anti-Corruption Bureau, ACB, within bracket ACB PS case number 04/20/2026 under section 120B, 409, 420, 467, 471 IPC, read with section 13(2) of PC Act 1988. No, anticipated bail, apprehending his arrest in connection with, okay. Apprehending arrest in connection with. Okay. Issue notice. Since Mr. Opada, learned standing counsel ACB, accepted notice, no formal notice is required to be issued. Staff call for the scanned copy of the case diary. Now, list this matter after a week.
Week, my lord.
Okay.
What's the fixed date?
Date.
August na.
Hmm.
Today is 24th. It can be on 30th.
Okay, on which date the interim anticipated bail at the prayer for interim anticipated bail shall be considered. Okay. Similar order?
Similar to us.
Okay. Hmm.
He's the applicant. JE, he's the JE. The other one is the JE.
Maybe.
Lordship, in fact, my respectful submission with this is now the contractor has already given undertaking to the department to complete the funding work till 30 September.
Okay. Then
Work is under-
he has admitted, he had attempted, so he should be
No,
punished.
Lordship, work is under progress, Lordship.
Hmm?
Work is under progress. Still construction is going on, Lordship.
Yes, but then money already received.
Lordship, their balance amount is also there in one of the projects.
We do not know, but then what was intention is clearly shown. Okay.
Obliged. Obliged.
Item number 9.
Lordship, item number 9 to 24,
Okay.
they are all connected matters, Lordship.
Mhm.
In the similar situated matter, Lordship
Mm.
has stayed the proceeding before the CGM. Lordship, I'll just
Okay.
punish. So, in fact, to this order, Lordship. it's
Whether the trial proceeded.
Lordship, FIR has been filed and investigation are going on, Lordship, against him.
Investigation against her,
Against the
the respondent,
complainant,
against the
complainant,
the
respondent,
the
complainant.
present respondent.
Yes. Cases registered against him is criminal breach of
Yes, yes.
trust, cheating, forgery.
So
Till returnable that, Lordship, the proceeding before
These
the
are similar?
state, Lordship, similar, Lordship. In the previous application also, I have annexed all the
yes, yes.
promissory note.
But
Lordship,
this
Lordship.
appears like that. He was the one.
He was the chairman at that point of time.
He was the
Lordship.
chairman.
He
and
coerced
then,
the
the
beneficiary.
amount is same from all.
No, Lordship,
Depends.
different beneficiaries, different amount, Lordship,
He asked for the percentage, 10%.
percentage.
Okay.
It's not
That is
clear
not
in
very
the
clear. That is
promissory note, but 10% was the.
That is why there's a problem here in Arunachal Pradesh. There are also middlemen. That is what the problem. always.
Middleman, Lordship, he in fact misled the beneficiaries, Lordship,
That is
saying
why.
that the amount will not be released if that amount is, that
That is why,
promissory note
because
is not signed.
Because of such person only, it becomes difficult.
But
the
then,
program.
later on, we found that he did not have any role at all,
Mhm.
Lordship.
He just.
He just wanted to mislead the
Oh, that
beneficiaries
these
and
people are
take
getting
away the
money.
money, Lordship.
Yeah.
So in fact, on that ground, Lordship, since it is not an imperishable debt, Lordship, so why we are before your Lordship. So abuse of the process of the court, it would amount to abuse of the process.
Mr. J. Jingam Jini, Land Council for the petitioner. Okay. The same type of petition, same kind of petition. Okay.
All of them. Lordship.
The present petition under section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023 has been filed. Praying for washing and setting aside of the criminal proceeding. In CR case may not be same.
A CR case, Lordship, I'll furnish the list of the CR case, summon dates, are
Okay,
different,
case
Lordship.
number will be different, huh?
Lordship, just furnish the
Share case. Register under section 138 of the Negotiable Instrument Act 1881, read with section 142 of the Negotiable Instrument Act 1881. And the summon also order dated, huh? Summon order dated, it will be different. Summon order dated.
Lordship, that would be different.
PPTA,
So while,
different.
Lordship, I am furnishing this, Lordship,
Hmm.
for the convenient. I'll just furnish.
Is this table reflect the correct date?
Yes, Lordship. These are all,
Okay.
the present case is item number 2, as per this list, Lordship.
So-
Serial number 2,
Okay, Societ lump. Societ lump would be.
Delang.
The criminal petition number would be. No. Okay,
registered
in this
in
case,
this case, Lordship.
in this case.
And trial court
Okay,
number.
CR
is
case number, then
7.
write 07/2026. And then the challenge order dated would be. It's a very-
03/06/2026.
This is what order?
Cognizance order, Lordship.
Okay, just a minute, huh? Then. Set aside and criminal proceeding complaint number so and so, read with so and so, comma, the cognizance order, cognizance and summon order, cognizance and summoning order dated 3/6. Twenty 2026. Issued by the which court?
CGM
Chief Judicial
Teju.
Magistrate,
Teju.
Teju,
Correct, Lord.
Chief Judicial Magistrate Teju.
That's 17.
Stop, huh? Para. Will not say anything then. We'll just issue notice. Okay, stay.
Correct.
That will be enough.
All right.
I thought of making observation, but then that will also not help. Okay, issue notice, returnable within 4 weeks. The petitioner shall take steps for causing of service of notice upon the respondent by a speed post as well as by usual process within a week, within 3 days from today. Staff. Call for the scanned copy of the relevant, scanned copy of the trial court record, huh?
Yeah, Lord.
Stuff. But here, the investigation against the respondent, that record would not be necessary here.
Lordship, if we take up this along with 172 and 171, since already case record has been called in this matter,
Okay,
in this matter will not be required.
okay,
We can take up this criminal petition along with rest of the petitions.
Okay. List a matter after 4 weeks, huh? Whether that criminal, that
That
case fixed-
order will be required, Lordship, that direction taking up this criminal
Okay.
petition number
No, whether that-
71
whether
and
that
70.
Date has been fixed in that case.
No, Lordship,
Okay.
returnable within
Stuff,
court.
huh? Fair. Having regards to the submission advanced by the learned counsel for the petitioner and on perusal of the record. A perusal of the documents on record. It is provided that further proceeding of complaint case being CR case number 07. Number 07/2026. So, pending before the learned Chief Judicial Magistrate Teju shall remain suspended till the next returnable date. Stop. It is submitted that the similar case is pending before this court, and the similar case pending before this court may be taken up together. So, well, similar case being
Criminal petition 171,
criminal petition 171,
2026,
2026,
172, 2026.
and 172, 2026 are pending before this court, and the same may be taken up together. Stop. List a matter after 4 weeks along with the aforesaid criminal petition.
Correct.
Okay.
Obliged, Lord.
The number will be different, huh?
Number we
Will be different. You furnish the number
will.
and then all same.
Hello.
Hmm? This will be, this all will be clubbed together. Not, list it like that only. Will it, this need to be clubbed together? All this,
All rest, yes.
okay,
Yes.
up to 24. How many matters?
Up to 24, item 24.
Okay, that's, okay. We'll take a break of 5 minutes, huh?
Item number 26 and 27.
Two 28. Yes.
Arrest has been by the other criminal petition number 230. By that I am, my lord, 482, my lord, praying for quashing of the FIR, my lord. So if the, my lord, item number 27 is taken up and I succeed, then my lord, the 26, my lord, need not be gone into, my lord.
Okay, so 27 is to be taken up.
My lord, my humble submission would be, my lord. In fact, my lord, the 26 it doesn't survive, my lord, because there is already an order by this court that no coercive action taken against the accused in item number 27, my lord. So there is no any, my lord, the question of, my lord, this recall of this NVW, my lord. In fact, my lord, on the very first day, this honorable court has directed them to approach the court for recall of the NVW, my lord. But as on that, they have not come with any, my lord, information or any update whether that NVW was recalled or whether they filed any application. Because my lord will see in the first day order, my lord,
The
it's a provision.
trial court is the, otherwise, the best court to approach for recalling of the NBW, BW.
And that was, my lord, indeed, my lord, it was indicated by this honorable court on the very first day, my lord.
What my submission is, if the item number 27 is taken up, the item number 26 need not be gone into. I am challenging the propriety and.
This item 28, sorry, 26 is for recalling of the NBW.
Yes, my lord.
Okay, and then what, this 27 is for
27 is for quashing of the FIR.
Challenging the FIR, my lord.
challenging FIR.
Yes, my lord.
Any stay order?
Yes, coercive action, no stay, no coercive action against the
Otherwise, the
investigation is going on.
Going on.
Yes, my lord.
Now, things
Do
have,
we have the case diary?
but
we
now
ha-
things have changed because the other day they have submitted that charge sheet has been submitted.
Is it?
Perhaps, my lord, whether it has fallen from us or not, my lord, I have the status report actually, my lord, regarding this
What it
case.
says?
And this is,
Order dated 25 to 25 5
In 27?
26.
Item 27?
27. Order dated 25 5 2000.
and my lord, if my lord if suppose my lord, the charge sheet is filed,
Hmm.
my lord, they have to even impugn the charge sheet now, right now,
Not
my lord.
necessary, my lord. That will not be necessary.
They have to impugn the charge sheet, my lord.
Yes, it was said, case has already been submitted into charge sheet. Then
Yes, my lord.
call for the record.
Yes, we don't have the, yes, my lord. TCR has to be called for in that case.
Then in that case, we'll have to call for the trial court record only.
Lodge.
Call for a scan. It was also called for the trial court record scan copy. We have not received.
Not received, my lord. It was, perhaps it was not called for.
Oh, 27.
The
Trial court record is there.
It's there, my lord.
Hmm. 30 August 20.
No, here also, the court, probably you may have to challenge this as well. Non-bailable warrant of arrest already issued against accused on the ground that he is not cooperating with the investigation and he is, this was 25, sorry.
Yes, my lord.
This is under challenge.
Yes, this was challenged, but my lord, in that case, there is no any interim as such, my lord. However, my lord, in main case, I would say in my lord, item number 27, there was a direction for no coercive action against the accused person.
Then nothing will happen.
Then
And then
nothing,
it's always better to approach the trial court just to recall.
My lord, that will, my lord, why I am challenging the legality and validity of the order. My lord, cancellation of bail, it is not a, my lord, simple, my lord, cancellation as well. That is without, my lord.
Bail was cancelled
Yes,
yes, my lord, bail was cancelled, my lord.
without giving notice.
without giving notice.
That
That has to be looked into, my lord. That aspect has to be looked into, my lord. Whether it was notice was given or not, that has to be looked. And that was too in the course, during the course of investigation, my lord.
And secondly, my lord, moment I appear before the court, my lord, the coercive action is relates to the, my lord, police. But that was an interim, my lord, that was given, but my client apprehends, my lord, approach, my lord, the trial court, my lord. So if 27 is taken up, my lord, that will.
Where his bail has been cancelled? By which order?
My lord, the order at page 46, my lord.
Order dated?
Order dated 10/6/2023.
No, 10/6, where do we find that the bail has been cancelled?
My lord, we kindly come to the, my lord, order passed by this
41.
honorable
Page
court, my lord.
41.
Mentioning here.
Just a minute, huh? 41 of item 27,
26.
item 26.
And that
second last paragraph.
Page
Page 42. my lord. It starts
42.
41. Lordship may come to page 42, second last paragraph. The above observation clearly shows that petitioner accused has willfully avoided participating in investigation, rather resorted.
Okay, this was interim bail.
Lordship, illegal interim bail, so and so is cancelled.
Interim bail only,
Yes, my lord, not absolute, my lord.
not absolute.
Yes.
Even
Because interim in violation, probably in the condition also, it must be there.
Yes, madam.
no matter here, what happened, my lord, the factual facts is peculiar, my lord. Interim bail was granted. If your lordship looks into the, my lord, the order, my lord. Page 35.
What is this? In the interim bail granted to applicant Sri so and so is cancelled. SI so and so deserves to be appropriately punished on dereliction. The superintendent.
What happened pursuant to the interim bail, I had, my lord, though there was no direction to appear, I had appeared before the IO. I have submitted all my documents, I have given my statement. Now, so far as, my lord, the bail is concerned, my lord,
Mhm. This order was passed in what? Oh, for release also, there is an observation that you have manipulated.
the case is purely, my lord, a civil dispute, my lord,
Maybe,
Look.
but then the conduct,
No.
we are here in, not on the dispute.
that's what, my lord, that was, my lord, totally, my lord, misplaced fact, my lord, the order has been passed, my lord. If your lordship, my lord, look into the, my lord, interim order that was granted, my lord, on 6/11/23. Thereafter, my lord, I had appeared before the IO at page 37. Page 37. My lord, I was granted interim bail on 6/11/23 at page 35. And page 37.
What
I
is
appeared.
37? What is 37?
My lord, my appearance, my lord, that was recorded, my lord, by general diary entry, my lord. Page 37.
You were granted interim protection in AB.
Lordship, my lord. AB number 15 of 2023.
Now, what is to be done? Just a minute, huh?
What my submission is.
Since there, yes, sir.
if the FIR goes, entire, my lord, proceeding goes, my lord.
Now, the case has
So far
already
as
been charge
submission of
sheeted.
the charge sheet is concerned, it is for them to support the,
Now, see, after FIR, investigation carried out. Then during investigation, let us see, just a minute. How the FIR will go after investigation? If the investigation substance, because FIR is not the, see,
Encyclopedia.
yes. But then
no, that's.
after
well, that-
investigation,
So they are.
if the charge sheet file, it's charge sheeted, just a minute, huh? Under what provision? What, for what offense? What was the offense,
Offenses
as per the S-
406, 420,
FIR.
465,
for?
406, 420, 465. Charge sheet, of course, I do not know, but not under what sections they have.
420, 406.
Well, this charge sheet-
Sufficient evidence has been found to proceed against the accused for offense. See, after investigation, they have found out.
No, therefore, my lord, what my submission is, right?
Now, the FIR, as you say, that it's not an encyclopedia. After investigation only, it will be confirmed that whether there is a prima facie case against the material against the accused for commission of the alleged offense punishable under section 120 or 406.
Right.
Now, after that, they have submitted this. Now, and thereafter, probably some other was passed, cognizance taken. You probably need to challenge that, those.
My lord, since my lord, the FIR
Because-
is, well,
FIR cannot go now. Because after investigation, only after recording the statement of the witnesses and after collecting the incriminating material against you only, the charge is filed. How the FIR we can just set aside and quash the FIR at this stage when the entire material is against you?
my lord, that's what my lord.
It's not a prima facie.
Grounds of my lord crossing of the FIR, my lord, are on a different footing.
Hmm.
And my lord, it is prior in time. I am challenging the FIR, the point at which.
But subsequently, but see, there was
Yes.
no stay. Subsequently, the investigation carried out.
Carried out.
It was going on, but in the meantime, it was found out
Lord,
there is incriminating material found against you. There is a prima facie case against you. That is why
Lord.
file charge sheet.
my lord, then-
Unless you challenge it, it will be, the charge sheet itself, it will be difficult. The FIR, how it will go?
my lord,
The entire investigation.
my submission will be, my lord, I am required to, my lord, I may require to my lord, challenge this.
The FIR may say, person died. You may challenge saying no name, nothing. Person died, am I responsible?
Yes,
But then subsequently found that it was you.
Exactly, I am on that point, my lord.
Hmm.
This charge sheet will be an document for them to support the FIR.
Mhm.
I am challenging the FIR for so many good reasons that it is a civil dispute.
Hmm.
That it cannot be, my lord, considered as a criminal, my lord, when it is, my lord. Now, the allegations in the FIR, according to them, are being substantiated by the submission of the charge sheet. So that will be a document to support the FIR. My lord, the initiation of the proceeding would be, my lord, by the FIR, whether it is abuse of the process of the court, whether it is an out and out a civil dispute, and all other, my lord, grounds that have been mentioned in the, my lord, Bhajanlal case and subsequent, my lord, decisions. So
Hmm.
I'll be challenging for that. My lord, my whole ground is that it is a purely civil contractual dispute, my lord, that ought to be, my lord, executed through the, my lord, this initiation of the proceeding. Now, whether any criminal act to constitute the offense of 420 and 465 and 406 have been made out by the submission of the charge sheet. So that will be a document for them, my lord. So if the FIR goes, the charge sheet automatically goes, my lord. The proceeding initiation of the, because that is already challenged. These are all subsequent event that has taken place. An investigation of the police, my lord, that cannot be, my lord, even stayed by the court also. So therefore, I did not pray for, my lord, stay of the, my lord, investigation. My lord.
Mhm. Now, let them also go through.
My lord, sir,
Hmm.
I will make some.
This is,
My lord, I will make submission on 26 first, my lord. Why, my lord? My learned senior counsel is saying, my lord, if FIR goes, everything goes. That means it is totally depend on this.
Ah.
If FIR doesn't goes, this survive.
Hmm.
That means it's
No, no.
premature.
not that, not.
If FIR doesn't go, my lord, the proceeding will continue, my lord. Then the NBW has to be given effect, my lord. Because there is a coercive direction for no coercive action as on that, my lord. That has not been vacated as on that. So once, my lord, if the FIR survive, then this will come, my lord. Meaning thereby it's a, my lord, premature as on that. And secondly, my lord will find the order passed by this honorable court on 22/10/25, my lord, by this coordinate bench, my lord, on criminal petition 228/2015, my lord. Item number 26, my lord, in item number 26.
22?
22/10/2025. This is the specific, my lord, the observation given by this honorable court in the last paragraph, my lord. Having considering the provision of section 72 subsection 2 of the BNSS 2023 and also considering the interim bail granted to the, my lord, it clearly says interim bail granted to the petitioner having been cancelled on so and so by the learned session judge Lower Subansiri District 0, the petitioner is at liberty to approach the jurisdictional court for recalling cancellation or the impugned non-bailable warrant of arrest, my lord. Here, my lord, there is no any whisper regarding, my lord, the legality, validity, or whether it was wrongly, my lord, issued. And first, my lord, interestingly, my lord, here they have only challenged the, my lord, order for non-bailable warrant of arrest. But they have not challenged the, my lord, the vacation of the interim bail order, my lord.
Cancellation.
Yes, cancellation they have to challenge, my lord. Then, my lord,
Probably the
NBW will come, my lord.
if you think the cancellation was illegal without giving notice, you need to challenge the cancellation order.
No, my lord,
If the cancellation goes,
against the cancellation order, my lord, there cannot be an appeal, my lord, as such, my lord. I can always go for a fresh, my lord, application for bail.
yes,
Now, I am confining my lord, challenge to the impugned order, whether on the facts and circumstances supported by law, the order could have been passed. Now, the order that has been read out, my lord,
22/10. 22/10/25.
22/10/25, that has to be read in the context of interim prayer I have sought for in the, my lord, petition. In the petition, I have sought for interim order of stay of that particular order. So the court is of the view that instead of staying this, you can approach, my lord, the trial court under that particular section, and then that court can recall. So that is confined to the interim prayer only.
And my lord,
So, and my submission is that if the, my lord, 27, item number 27, I succeed, then this 26, item number 26 need not be gone into. But if I fail, then, my lord, this independently, that order, again, I have to, my lord, argue, my lord, and your lordship will consider the order.
that is true, that is true. If this,
that is the reason I'm saying this is premature, my lord. As on that, my lord.
Premature, my lord.
My lord, why? Because, my lord, cancellation, my lord, senior counsel is correct, my lord. Cancellation of bail is a, my lord, interlocutory order. Now, NBW is also an interlocutory order. I have the judgment which says the 482 is not maintainable against the NBWA order, my lord. Non-bailable warrant of arrest, my lord. 482 in exceptional circumstances. Now, for demonstrating the exceptional circumstances, they have to satisfy this court that the cancellation order itself is against the law. They are not saying NBW is wrong. They are saying cancellation was wrong. Subsequently, the issuance of the NBW would be wrong. But they are not challenging the cancellation order. I would say, actually, my lord, cancellation, not the cancellation word, since it was an interim bail protection. Actually, it was supposed to be the vacated, the learned court below has vacated the interim protection. It was not made absolute, my lord. So now, without challenging that order, my lord, how they simply come and approach this court to regarding the issuance of non-bail warrant of arrest? If they are, in fact, my lord, they are all genesis is all all based on, my lord, this cancellation of bail order, my lord.
unless, because interim protection already vacated. Now the court has issued NBWA. So here again, I am saying that the trial court is the proper court where you can approach and pray for recalling of the NBWA issued against it. Appear the trial court and request for recalling of the NBWA. Since I am appearing, no need. So automatically, it is normally granted only before the trial court. So now, if you are insisting for this 27, now I could understand that what you are saying is if the 27 is succeed, then 26 of course automatically goes. So here in 27 again, what I'm saying is since charge sheet already filed, it is to be, the entire thing is to be considered now.
Yes, well, that will be a document for them to
Document.
support.
Now,
Lordship, my lord.
now they will be allowed to see the record and for advancing argument.
Yes, they can, obviously, my lord, in support of the, my lord, FIR, they'll, apart from the legal.
Now he's not pressing, that means 26 now at the moment.
Yes, my lord.
Because he's pressing for the 27.
My 27, if they are pressing, my lord,
Ah.
then my lord, the learned senior counsel, my lord, they have only challenged the FIR.
Hmm.
They're only confined to the FIR.
Yes.
No doubt, my lord, the charge sheet is supporting us, my lord.
Yes.
If charges is filed, their case is more aggravated because, my lord, the sufficient incriminating material has been found.
Mhm.
Now, from the
Yes.
FIR itself, the learned, the accused, the applicant has to satisfy this court that FIR does not disclose any commission of cognizable offense or absolutely not cognizable offense. Only that is the ground, my lord. Because, my lord, if it is civil nature, no offense. If it is non-cognizable, then FIR doesn't lie. The only ground would be, my lord, the FIR does not, in fact, my lord, indeed disclose any cognizable offense to that extent only. Because since they are not challenging the charge sheet, they are only challenging the FIR. They cannot advance argument on the charge sheet that this material cannot be taken into consideration or not, since they are not challenging it. If they challenge, they can say, although FIR disclose a cognizable offense, but later on the material whichever has been collected, that does not substantiate or that is not sufficient enough to, my lord, to charge sheet this section and all. my lord.
Submitting.
Yes, my lord.
Council is submitting. That will be your document.
Yes, my lord.
In-
Yes, we'll argue on the FIR, my lord. We don't have any difficulty, my lord. Let them argue on the FIR itself.
That can be.
Okay.
Well, if I fail, then my lord, second will, my lord, 26 will come. That is a different issue, my lord, at this stage, my lord. No, Lordship is taking up the, my lord, item 23, 27, my lord. FIR, Lordship may come to, my lord, page 24. Relevant, my lord, page 27.
Just a minute, huh?
May I read?
Just a minute. Huh? Yes. Page 27.
27.
Yes, please.
May I read, my lord?
Yes.
With due respect, I have the honor to inform you that I had deposited and transferred a sum of rupees 34 lakhs only on so that a sum of rupees 20 lakhs on 27/22 and sum of rupees 7 lakhs only on 21/7/22 through RTGS and EFT, in total 61 lakhs only at the rate of rupees so and so as advance amount of supply of iron bars of different size for my shop, Messrs. Trade Agency, Hapoli. In this regard, it is to inform you that till 29/7/2022, I have received materials, that is iron bars of different value of rupees 27 lakhs 10,000 so and so only. But above named accused has not sent further material even after repeated requests. Therefore, I had served him a legal notice so also to accused. But after receipt of legal notice, the above named accused have sent a material, that is iron bars of different value of rupees 4 lakhs 2,000 so and so only. Thereby till date I have received materials of rupees value of rupees 31 lakhs 21,000 and so and so. Detailed bills and date of receipt of the materials are enclosed as herewith for reference. It is informed you that the said accused person has not only cheated me, but he has also cheated state exchequer by using same invoice number to send two different trucks. The copy of fake bills are enclosed herewith. It is pertinent to mention here that weight mentioned in bills and measurement receipt are different from actual weight received by me. Therefore, the evidence of difference has been admitted by accused person in telephone conversation between me and accused person at the time of unloading of material and re-measurement. Thereby, the accused person has still to return a sum of rupees 29,28,000 so and so 100. Thereafter, I have requested above name accused on several occasions to send materials on or return the remaining advance amount paid to him. However, instead of sending the material to me, he has pretended to send me materials by sending me fake and false counterfoil invoice, track number so and so, etc. WhatsApp. The WhatsApp such are enclosed herewith for reference. But till today, above named accused person has failed to send material as agreed, nor return my remaining advance amount in cash. Thereby, the above person accused has cheated me repeatedly with a malafide intention to usurp the misappropriated my hard-earned amount, and he also breached the trust of our business transaction. Therefore, I would like to request you to kindly investigate and so and so. So my lord has seen, my lord, basically, he has placed orders for supply of certain goods of amounting to rupees 61 lakhs and odd. Out of that, he has received goods worth 31 lakhs and odd. And he is yet to receive about 29 lakhs, according to him, the goods. So therefore, I have cheated. But it's basically a dispute arising out of a contract between both the persons. Which is purely a civil nature. He is entitled to the agreement of refund of not only the refund, but also the damage, etc., my lord, and interest in a civil court. Now, adopted this, my lord, as a shortcut method, being a zero, I am from Gauhati. I'll be, my lord, harassed by visiting, my lord, zero off and out at the hands of the police as well, my lord. And even in the 26th, as I have said, my lord, in spite I have appeared before the, my lord, police, it was projected just because there was a statement that I did not physically present before the OC. So therefore, the entire, my lord, things have been taken in a different way. That is the first thing, that this is a purely, my lord, out and out civil dispute. Now, secondly, what are the ingredients, my lord, of the offense of my lord, 420, my lord, cheating? My lord, the dishonest intention, it should be at the very initiation, my lord, at the very beginning. My intention, my lord, fraudulent and dishonest intention, my lord, must be at the very beginning. Right from the, my lord, Hidayat Ranjan, my lord, Burma case and subsequent, my lord, various cases would go to show, my lord. There's a distinction between, my lord, offense of cheating and, my lord, breach of, my lord, agreement. If I don't have the intention to cheat at the very beginning, and subsequently I could not perform the agreement or assurance whatever I have given, that cannot be taken as a ground for cheating. This way, my lord, the business transactions, my lord, if are taken, my lord, into the fold of, my lord, criminal, my lord, proceeding, it will be difficult, my lord, for the purpose of commerce and trade.
Difficult for whom?
my lord, for the purpose of trade and commerce, my lord. Because every contract is, my lord, every supply or whatever is a contract, my lord. Now, cheating has to be, my lord, at the very inception. I have presented myself that I am a dealer, but then I am not a dealer. And I have taken money. So that means at the very beginning, I had the, my lord, intention to cheat him or deceive him. My fraudulent intention at the beginning. Now, there is no dispute. I am a dealer. There is no dispute. You have paid the amount. I am not disputing. But I said I have supplied more than that, what you are saying. But then for a moment, I am not going into that. Even if it is on the face value of the FIR, it is taken. What it, my lord, projects that 61 lakhs have been paid to me for supply of certain goods. That way back in 2022, sometime in July 2022. I have supplied materials according to you. You have received 31 lakhs. And in 2023, June, after a year, you file an FIR. And the FIR is also absolutely silent that I had the, my lord, this intention at the very beginning. If I had this intention at the very beginning, I would not have sent at all any goods. Second aspect of the matter, you'll also find what the allegation is with regard to the, my lord, 465 or so, my lord, that I have given, my lord, forged or fake invoices, etc. These, my lord, invoices must be available with the case diary or, my lord, the charge sheet, my lord. Police must have taken into note because, as I have showed, my lord, that on 11 in the other case, my lord, that order is available. 10/11/2023. I have deposited all these, my lord, receipts, invoices, everything to the police. So now police has, my lord, whether in course of investigation after receipt of these invoices, page 37 of the other case and the
Invoices, according to you, 65, he is still entitled around 29 lakhs. You have, according to you, you have all supplied or
no, I said, my lord, in my petition, I said 32 lakhs and all I have sent you covered by 2 invoices. Those are annexed as page 13 and 14.
he probably is not disputing that whatever he has received. Thereafter, he says that you with the pretended as if you have sent, but I never sent. Saying that you have sent truck, double sewing, etc.
Yes.
And then 29 he yet to get,
Yes.
and for which you are lingering and then cheating, pretending that as if you have sent,
Yes.
but then not sent.
But these are all
That according to him,
Lodgement.
is amounts to breach of trust and cheating.
Lodgement.
Not the already supplied one, already handed or given to him.
No, but
The material which you have supplied for certain amount is admitted. But then thereafter only the cheating allegation.
so therefore, my lord, the question would
Otherwise, the deal was purely a commercial, means the business transaction only during. But then thereafter, when you stopped and when you started pretending, then allegation comes.
my lord, that is, my lord, things, my lord.
Hmm.
Therefore, my lord, the apex court has said, my lord, this, my lord, fraudulent and dishonest and fraudulent intention has to be at the very inception. At the very,
No.
very beginning.
Now in the subsequent, because the payment was also not at, probably at one go. It was also subsequently paid. It's a continuous. In
It
the
is-
process,
It is
he
within
has
a,
deposited,
within a period of 5 days or 6 days. He business account, in the business account, he has deposited about, my lord, 34 lakhs, my lord. And I have supplied 32 lakhs and odd. And then, my lord, he, again, my lord, these are all documents, my lord. I have also paid subsequently 50,000 because he said that he received certain short amount, short supply. So he wanted some amount. So accordingly, 50,000 was assessed. That was deposited. So these are all, my lord, matter of, my lord, civil code, my lord. Whether there was any shortfall, whether, my lord, the agreement, what was agreed between the parties, the mode of payment, etc., my lord. Not by way of, my lord, police, my lord, saying, my lord, whether now the police, the allegation as it stands, my lord, then every agreement, if fails to be, my lord, discharged by the other party, it will be amount to a, my lord, criminal offense, my lord. And of course, my lord, I have not seen the, my lord, charge sheet and the case record. That is another thing, my lord. Because I do not know with regard to the finding of that.
now because the charge is already filed, you can obtain copy. If you want,
Yeah, that. my
you are
lord,
entitled otherwise
yes,
now.
Yes.
Since the case has already been charged sheeted,
Lordship.
the accused is entitled for a copy.
Let me obtain the, my lord,
That
the
will be better,
charge
because
sheet.
for him also, he also need,
Lordship.
the prosecution also required to go through the charge sheet.
My lord, actually now when the charge sheet is filed, my lord, they even have then, my lord, the opportunity at the stage of CC, my lord.
That is what I'm saying.
Yes, my lord.
For discharge,
Yes, my lord.
can
They
also
can
make
go for it also, my lord.
discharge
My lord,
petition also can
notwithstanding,
file.
my lord, that on the next date I'll, my lord, place, my lord, notwithstanding submission of the charge sheet, my lord,
Hmm.
the FIR, the challenge to the FIR is still maintainable and there are numerous judgments, my lord, I'll place. my lord.
My lord, we'll argue, my lord, as the learned senior counsel has earlier also, my lord, I have in fact indirectly I have suggested that it should be better if it is challenged. But since the learned senior counsel insisted that it is maintainable, no doubt. But my lord, now he has to be confined with the FIR only if it is not challenged the charge sheet, because meaning thereby he is not disputing the charge sheet. So far as FIR is concerned, my lord, we are ready to argue on the FIR also. Now, my lord, the material from the FIR itself, my lord, as your lordship is aware, the FIR is not encyclopedia of entire fact,
Yeah.
but it's just an initial statement to set criminal process into motion. Now, my lord, as your lordship is aware, the power under section 528 is wide in nature and it has to be exercised sparingly with circumspection and exceptionally rarest of the rare case where, my lord, it is patently clear that the complaint does not disclose commission of any offense. But my lord will, even my lord, I don't need to refer the all the paragraph. I will only refer the third last paragraph of the FIR, my lord. That itself disclose the commission of cognizable
That's
offense.
what I'm saying.
Basing on that only this FIR survive, my lord. And it's required to be, my lord, it's not required to be interfered with, my lord. My lord will see in page number 28, my lord. Page number 28, my lord, the parts 3, I will start from the line. The advance amount paid to him. However, instead of sending the material to me, he has pretended to send me the material by sending me the fake and false counterfoil.
That becomes.
Here clearly disclose the commission of cognizable offense. On this count itself, my lord, this criminal pretense is liable to be dismissed, my lord.
Fake and false counterfoil.
That's what, my lord, on 11/3, I
Invoice,
have
back
deposited
number, etc.
all these documents with the, my lord, police. Police will investigate. These are all, my lord, computer generated, my lord, documents. And these e-way bills are one cannot, my lord, submit a fake document because it in every checkpoint, this is, my lord, entered. At every checkpoint, these are entered. my lord.
And-
Nonetheless, my lord, I'll let me go through the, my lord, the charge sheet, my lord, and if,
That will be better.
yes,
And then if you require,
Lordship,
probably you may have to challenge the charge sheet itself.
I'll see
Because-
that, my lord. I'll see.
It's a subsequent.
My lord, without challenging the charge sheet, my lord, even how it can be relied upon, my lord. That is the difficulty, my lord. And
Difficult.
right from the beginning, my lord, I've insisted, my lord, because it's good. Although it's our document, but it's good for them also, my lord, charge sheet. Because, my lord, in the FIR itself, my lord will find the WhatsApp chat are enclosed herewith for reference.
Or-
Again, also, he has also, my lord,
Otherwise, till then, it was good. It was a business transaction, civil in nature, but then when it says that pretended and then false invoice, etc., this becomes a prima facie. So it attracts the 120 or at least 420.
I'll just go through once. I'll go
It
through.
will be better.
I'll give a reading.
Third, Mr. P.J. Salke, Lana Senior Counsel, assisted by Miss. Okay, Lana Counsel for the petitioner. Also had Mr. Kirte, Lana additional PP for the state respondent, and Mr. Tama for the Mr. Tari for the state, private respondent number 2 staff. Okay.
He has interest, but not a party to that.
Pass order in 27, will pass order in 27.
my lord, 27, my lord will pass because the Lana Senior Counsel would like to go through the record. But my lord, 26 is, my lord, I am humbly submitting, my lord. 26 is still they have time, my lord, they are protected. They can approach the Lana court below. Why let this matter?
Will go along with 27.
Well, let this, my lord, let this matter be closed, my lord. If my lord, what my lord humble submission would be,
It will not be closed.
my lord, what my humble submission would be, my lord, if they approach the trial court for recall, if they agree by the order from the, if the order become impugn, then they have to come, my lord. Now, my lord, how they can wait for 27 on, how they can wait for the 27? If 27 goes,
Now probably they will have no option, because when you go for the obtaining certified copy also.
and my lord, perhaps AB is still pending. Because interim was vacated, interim was cancelled, but my lord, AB is not, whether the AB was dismissed or not, nobody knows. The application is pending, meaning thereby, my lord, anticipatory bail.
Like an appropriate application before the, I think, the
I'll,
trial.
I'll just give it.
That will help, because normally what the trial court do is when the the accused appear, personally appear, and then make a prayer, then automatically it is recalled only.
No, here, my lord,
Because
what
you will
my
undertake-
client is
because-
facing, my lord, the facts which way, my lord, it has gone there, it is not correct. And if these facts remains,
That
at
is-
least some clarification is not given by this honorable court, it will be very difficult for me to appear there, my lord. Because the court has already made up a mind, or already, my lord, has recorded that I did not appear before the IO, and that I, my lord, instead of, my lord, depositing the,
Now in a criminal petition, now then you have to file AB then again, if you're apprehending arrest. Protect till such.
My lord, they are enjoying everything, in fact, my lord.
that's
No
what-
coercive action in the, this main,
Oh, where
27,
where is that order?
my lord, will find it.
26.
page 27, but in, I don't know what 27.
27, they are enjoying everything. AB is pending.
Then you are.
My lord, bail only interim is vacated. NBW,
Protection.
they are enjoying everything in 27, my lord.
Protection.
My lord, I request my friend to hold his, my lord, argument for the next date of hearing, final disposal. my lord.
Not on
That
20,
day,
20.
I have understood his argument that challenge to the FIR is not maintainable. I am not.
No, I am not on,
my lord.
I am not on maintainable.
Secondly,
I
my lord, 26 is not maintainable because I have not challenged the, my lord, interim order of cancellation of bail. My lord, these two factors, my lord, I have.
my lord, I simply make submission on 26. This is premature. And so far as 27 is concerned, my lord, I am not saying it's not maintainable. My lord, I am saying that if charge sheet is filed, my lord, and it will be better, they have to challenge it. Otherwise, my lord, they will be.
Which order he is protected? Order dated?
My lord,
23,
23, 10, 25, my lord. In item number 27, my lord.
27.
2310.
Yes, my lord.
Okay, by the first order.
Yes, my lord.
Okay.
The last it said, my
I
lord, having
think,
considered
since-
coming till returnable that no coercive action shall be taken against the petitioner. However, the investigation authority may proceed with the investigation and the petitioner shall cooperate and appear as and when called for investigation.
It should be fixed a date for, my lord, final hearing. My lord, both the analogous hearing can be done.
Okay.
My lord.
Then in both the case, separate order need to be passed then
Yes,
in
my
that
lord.
case. Okay. Same, huh? Mr. After this, huh? Is requested come at least this matter after
4 weeks, my lord, I would pray, my lord, sometime on, my lord, 28th, my lord,
28th of
August.
28th August 2026. So in item 26, there is no interim order.
No, my lord.
Okay. Okay, then in item 27 come, huh? Same, huh? Present. After that. Here also similar order?
My lord, only one clarification required in item 27, my lord. Since charge sheet is filed, my lord, there is no any stay, my lord. So coercive action is in respect of the investigation, my lord. Now, my lord, it may be clarified that the trial court may proceed with the trial, my lord, matter, my lord.
There,
When
since
charge sheet is
it's only
challenged,
coercive-
my lord, when
no,
charge sheet is challenged, my lord.
Not state, not challenge, charge sheet not challenge.
state, not
Only,
state.
Well,
Trial court can always
only
proceed.
FIR is challenged. It is not, FIR was not state, only no coercive action against the, my lord, the accused by the investigation officials, my lord. Now, charge sheet is filed. This may be clarified, my lord. Otherwise, it will be difficult for the trial court to proceed with the matter, my lord. It will amounting to stay of the, my lord,
My lord,
trial proceeding only.
charge sheet has been submitted, my lord. Till that, my lord, I have not received any summons. Whether, my lord, that has been placed, my lord, that will take its own course, my lord.
The clarification may be made, my lord, because they are,
I think to be clarified, my lord, no coercive action, as he said, my lord, is only confined to the investigation. Since he is saying that charge sheet has been submitted, of course, my lord.
Then if that was only for
There may not be any,
for the time
there may not be any
period of
action.
investigation, then
Yes.
that goes automatically.
it automatically goes, my lord. That may be clarified, my lord.
There may not be any, my lord, extension of the interim order, my lord, what was passed earlier, because that has already culminated into, my lord, submission of the
Yes.
charge sheet. But rest laws take its own course, my lord. The court, trial court will proceed.
Okay.
It is my application, it is not his application, my lord.
It is some, Mr.
Because it may happen, I may have to, like, challenge the, my lord, cognizance order also if it has taken, my lord. And scan copy of the records may be called for, my lord.
Okay, it is submitted that the after completion of investigation, the case has already been submitted with the charge sheet. And in view of that, the submission said, Mr. P. at the addition PT submits that since the case has already been submitted after completion of investigation, the case has already been submitted in the charge sheet. Come and the interim order dated 23/10/2025. The interim order protecting the petitioner from taking any coercive action against him during the investigation period. In view of the submission of the charge sheet. Culminated in with the submission of charge sheet, and therefore it automatically goes. Okay, in view of the above, the interim order protecting the accused from taking coercive action during the investigation periods, investigation period, no longer survived. It doesn't,
It become infructuous.
it becomes
Infructuous.
infructuous. Stop, huh? Is stands vacated, having become infructuous. Right that way, huh? Stop, huh? Para. Is prayed for by the Land Council for the petitioner, comma, list this matter on 28,
28.
8,
August.
2026. Okay. So in the meantime, whatever steps is to be taken, you can take.
Updated this year.
And
Lord,
on which,
my lord,
on which
case
date?
record, my lord,
Is-
since they are saying, my lord, charge sheet has been submitted. Perhaps charge sheet has come on the record,
Yeah.
perhaps.
Updated scan copy this year, my lord.
Okay.
Updated.
Charge sheet is record.
Charge sheet is there, so the latest order probably would be required.
Yes,
Yes.
my lord.
Hmm.
Yes.
This will remain probably, it will.
Yes, my lord. This if it is a scan copy, perhaps, my lord.
Hmm.
The updated scan copy of the TCR.
Okay, on which date? Sorry, the, okay. It is to be by the registry only.
Yes, my lord.
Okay.
Absolutely.
In the meantime, the registry shall requisition for the updated scan copy of the trial court record.
Yes.
Okay.
Deeply obliged. my lord.
Okay.
My lord, date has been fixed on 2/8.
28 August.
Okay.
Finish. What happened?
Item number 28.
28, yes. Your lordship, we,
We'll finish it
okay.
instead of sitting at 2. Nothing,
Your
if
lordship,
there is anything to be,
Yeah, the matter may be fixed after 3 weeks,
one?
your lordship.
Item
28,
28.
Yes.
Read for by Miss,
If I may, my lord,
you are also here.
yes, I'm on behalf of the petitioner. The
Okay.
instruction of senior counsel, Mr. P.K. Tiwari. It may be listed after a week, my lord.
After a week.
Yes, my lord.
No, your lordship, we are praying for 3 weeks because we need to file our affidavit in the matter.
If it pleases my lord, I would like to respectfully draw your lord's attention to the last order passed by this honorable court on 12/5/2026.
Yes.
My lord, in point number 7, the parties were directed to provide the list of dates and bullet points. The list of dates and relevant facts has already been provided by
The
us,
order dated,
12/5/2026.
12/6,
it's 12/6, I could see.
12/6,
Last order is,
12/6, your lordship.
And then, my lord, in point number 8, respondent number 4 was directed to file an affidavit in opposition, but they haven't filed it yet.
so
lord,
let them
in
file,
point-
let them, you are for respondent number,
R4, your lordship.
or for not yet filed.
Not yet filed, your
Okay,
lordship.
then in that case,
And in point number 3, my lord, the state government was instructed to conduct an inquiry into the minutes of the 2 GBC, but they haven't submitted the status of the
Status report. State is ready, otherwise
We have filed our affidavit numbers for 2.
already filed
Yes, ma'am.
after this order,
After
12/6.
12/6.
There is a direction,
No,
No, my
before.
lord. Before.
finding inquiry.
Oh.
The fact finding inquiry was constituted on so and so, but the same did not make any progress.
State response. Like,
Where is the direction, Land Council?
followed by. Like, yeah.
State was to file an affidavit to inform the court within the inquiry regarding the inquiry. Okay, Mr.
T longer.
Land Council for the petitioner. Miss,
My lord,
one more, Land Government Advocate for the state respondent. How much time?
3 weeks time, your lordship, from our side.
a week, my lord.
Miss, one more? Have you seen the last order?
We have communicated, my lordship. We haven't received the instruction yet.
Although they have communicated, however, the instruction is still awaited. And they have to see if there's some time to, some more time. Please,
R. Takam.
Planet Council appearing on behalf of the respondent number 4. Also praise for. Father, 2 weeks time to file affidavit now. And in view of the work and express the respondent can granted by 2 weeks time to obtain the arrangement. Now, the respondent number, the state respondent is granted. State respondent,
If I may, my lord.
yeah, 2 weeks time to obtain instruction and to file. File. What is to be filed? Report is to be filed or what? So to the.
Inquiry.
Yes.
Inquiry into the missing DPC minutes.
Okay. So, and to submit written instruction, huh? And in fact, the respondent number 4 is also granted. Is time to file. Yeah, that will be not. This is not after 2 weeks.
If I may, my lord, in point number 6 of the last order, it has been observed that if no affidavit is filed, the matter would be heard on the basis of materials available on record. So I kindly request you to list it after a week. Point number 6.
Yes, you want hearing today,
After a week, my lord.
after a week. Okay, let us, it won't make much difference.
Yes, your lordship.
Okay, after 2 weeks. Okay.
After 2 weeks, your lordship. Okay, oblige your lordship.
If you want a particular date after 2 weeks,
Any fixed date?
Earliest date, my lord.
when?
Earliest date.
After
As per
2 weeks would be August 5. Okay,
August 5.
Friday, your lordship, the Friday
August
on 7th.
7, okay.
Yeah.
Great for list this matter. Again on August 7. Okay, next.
Oblige your lordship.
Item number 34.
This is again for crossing of the Milord FIR.
34 is also crossing of FIR.
Lodge.
Okay.
Apparently, my lord,
Whether the respondent
my
is
my
present.
friend is appearing.
Okay, so have you filed any objection? No. You have filed? Then it will be fixed for hearing, Hearing or admission?
Admission, my lord.
Admission, okay. Mr. E.J. Saikia, Line Senior Counsel, assisted by Mr. Line Counsel for the petitioner. It's Mr. And also Mr. Taja appearing on behalf of K. Taja, appearing on behalf of Mr. S. Cohen, Line Counsel for the state, Counsel for the private respondent staff. As requested by both the Line Counsel for the party, please this matter.
If not inconvenient, my lord, 31st of July.
31st of July. Good. For admission.
In that case, let me on 28th again, my lord.
28th August
August.
for admission. Okay.
Interim order pass, alia mein
The interim order passed earlier shall continue till then. Okay.
Item number 36 and 37.
My lord, if I may.
What is this? This is new.
Actually, my lord, we have filed an IA in a pending criminal petition, my lord.
For what? IA for what?
IA for preponing the date of the criminal petition, my lord. Actually, my lord, the criminal petition is fixed on
When it is fixed?
14th of August, my lord.
14th of August. When do you want?
We want a date, if possible, before the 4th of August, my lord.
Have you informed the other side?
Notice was given to them, my lord, before during filing, my lord. During filing, notice was given to them. Information was given, my lord.
Date was fixed on 14 August.
Actually, my lord, what has happened,
It was with the consent.
that is an issue, my lord. That is why what I'm submitting is, my lord, when the matter was taken on the 2nd of July, consent was taken from us, but we did not have the knowledge.
That can be changed.
Lordship, may I, Lordship? Lordship,
Preponed. Okay, that can be postponed, preponed. Some date, he has some inconvenience. It's only prayer for the preponing of the date only.
Yes,
If
my lord.
there is no problem, can allow just the change of date only.
Yes, because my lord, on the 4th of this August, my lord, the execution case is fixed before the learned session court allow.
Execution is fixed. Then it will be difficult. It will have to be taken prior to date. 31st.
That is why we are praying that, my lord, if it could be taken on, the matter could be taken before the 4th, the main case, my lord. Because our prayer for interim has not been considered till date, my lord.
On 3rd, then 3rd. 3rd August.
My lord, if the matter could not reach a little date before 20 Tuesday, my lord, or 28 Wednesday, this Wednesday, my lord.
Mr.
Gitalo, my lord.
Planning Council for the petitioner. Where is Jeannie, Miss Jeannie? Some difficulties because it appears that at the time of fixing, date was not agreed upon. And then date, it appears that it coincide with. 4th, it is fixed for. There.
At Alo, my lord.
Okay,
The learned.
then that becomes that will be difficult. Whether. Just a minute. Also had Mr. Planning Council appearing on behalf of Ms. Jeannie, P. Jeannie, Planning Council for the respondent. Respondent, staff. Para. This is in IA, huh? Okay. The applicant petitioner. File this interlocutory application. Seeking preponing the proceeding of criminal petition number 17. It's 17.
17, my lord.
Okay, 17/2026. Which is fixed on 14/8/2026 to a date before 4/8. No, fixed on 14/8. It's a 14/8.
Yes, the criminal petition is fixed on 14/8.
14/8.
Yes, my lord.
Okay. To a date before 4/8/2026. On the ground that what is fixed there before the trial court?
The execution petition.
The execution petition filed by the respondent
Yes, my lord.
before the
Before the learned session court.
before the learned session court allow is fixed on
4th of August.
August 2026. It is It is submitted that in the criminal petition, no interim order protection has been granted. Stop. And in the and unless the date is preponed and the interim prayer is considered, the applicant petitioner would be cause prejudiced, cause serious prejudice, and the criminal petition would also become infructuous. Stop. Mr. Lolen, Planning Council appearing for the respondent clearly submits that submit that
In the above circumstances, he has no objection if the matter is fixed on, we'll say, 3rd August. Okay?
My lord, we had a small prayer regarding
Hmm.
it, my lord. Supposing due to some issue, some positive time, the matter could not be taken up, your honor, then there will be an issue regarding that.
No, 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 then nothing will happen. You have to apprise this, 3rd, okay. Stop. In view of the above, this interlocutor application is allowed, and in view of the above, the 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 prayer for reponing of this interlocutor application, praying for reponing of the date fixed on 14, preponing of the date fixed on 14 August 2026 is allowed. Stop. Accordingly, as agreed upon by the Rani Council for the parties, the next date for the criminal petition number 17 AP 2026 is fixed on 3 August, 3/8/2026. With the above, this IA stands allowed and disposed of. Stop. Then in the main case, para had Mr. Talo, Rani Council for the petitioner. Also had Mr. Lolin, Rani Council appearing on behalf of the respondents. Stop. In view of the order passed today in IA number 74 AP 2026, the date as fixed earlier on 14 August 2026 is preponed and is fixed on 3/8/2026. Stop. Accordingly, list the matter on 3 August. Okay.
My lord, a small prayer, my lord.
Hmm.
My lord, can my lord kindly consider on 31st of July, my lord? 31st of July, my lord.
31st.
31st.
31st is because that falls Friday, and then probably Friday.
Yes, no, 31st of July,
Hmm.
my lord.
I think you will face problems. That will be better. 31st, the judges from Gauhati will sit, and then if he leaves, it may not be taken up. Huh? Okay.
But
Finish, Lodge.
Okay. Yeah.